Today we are going to learn about copyright infringement and territorial jurisdiction. Okay, so let us first understand what does copyright means. Copyright basically is an intellectual property category that applies to works of authorship, and India's copyright legislation applies to any work made and fixed in tangible form, whether registered or not. Uh, Copyright confers exclusive rights on the owner and protects the owner and his work from reproduction, dissemination, and adaptation. Copyright protection typically lasts 70 years after the death of the work's creator, after which the copyright is either renewed by the work's subsequent or purchasing owner, or the work enters the public domain. Copyright infringement involves proving the rightful owner of the material, actions that infringed upon unique rights, and prove that the defendant's action exceed fair use standards. Copyright enforcement is in India is based on judicial precedent and case laws typically handled through claims brought to civil court. Enforcement is easier when the plaintiff has registered the copyright shortly after its creation and clear documentation exists. Further understanding this concept in depth. Copyright infringement is a complex issue requiring consideration of territorial jurisdiction. Each country has unique copyright laws and regulations, making territorial jurisdiction crucial for legal proceeding. Online content can be easily accessed and distributed across borders, making jurisdiction determination challenging. International treaties and agreements like the Berne Convention provide a framework for copyright protection across multiple countries. Some countries may have territorial provisions in their copyright laws, allowing them to assert jurisdiction over copyright infringement affecting their citizens or interests. Copyrights do not require a material form and can appear in objectively viewable form in multiple physical locations. The Berne Convention states only two forms of use are relevant for the territorial scope of sovereign powers and subsequent applicability of copyright law: use and free use. Let us understand the concept by some case studies. So, our first case law is University of Oxford versus Rameshwari Photocopy Services. So, this case revolves around whether the preparation of course materials as photocopies constitutes copyright infringement or if they are a part of course instruction under Section 52 of Copyright Act of 1957. So the judgment of the division bench of the Delhi High Court in the case of University of Oxford versus Rameshwari Photocopy Services highlights the importance of fair use, public domain, educational exceptions, and accessibility to the masses. The Indian copyright law is unclear on whether it is a natural right or statutory creation, but it is based on creating an artificial market for intangible works through state given sanctions for limited monopolization. Copyright requires a balance between limited monopolies given to the authors and consumers' access. In recent decades, the focus and perspectives of copyright owners and private property have been dominant in copyright law, particularly due to major shift towards digital rights. In this case, the plaintiffs argue that the use of specific pages of their copyrighted books by Rameshwari Photocopy Services as part of course material amounted to copyright infringement under Section 51 of Copyright Act of 1957. The plaintiff the plaintiffs argue that the photocopies were used solely as book and were commercially exploited by the service, violating their rights under Section 14 of Copyright Act. The defendants argue that the photocopies fall within the exception under Section 52 of Copyright Act, and there is no effect on the plaintiffs due to nominal charges fixed by the photocopy services. The Delhi High Court in 2016 issued a historic judgment in the jurisprudence of copyright law, reminding the world that copyright is not a natural right of publishers and that there are exceptions to the general rule of copyright infringement. The court held that the preparation of course material for education does not violate the rights of the copyright holder or amount to copyright infringement. The case emphasizes the importance of fair use and research in the current world. Courts should prioritize students' needs over those of rich publishing houses unless there is a legitimate infringement of their right. The second case we have is Bombay High Court's landmark Wink versus Tibbs judgment. Wink filed a claim under Section 31D of the Copyright Act of 1957, claiming that the online music streaming and downloading platforms are not eligible for reduced obligatory licenses under Section 31D. The court had to decide whether Wink Music was entitled to the benefits of a discontinued compulsory license under Section 31D. Bombay High Court ruling on music streaming licenses. Online music streaming sites like Wink Music are not eligible for discounted obligatory licenses under Section 31D of Copyrights Act. The court stressed the importance of licensing agreements between music streaming companies and copyright owners. The decision strengthens the rights of copyright holders, requiring online music platforms to secure adequate license. The judgment emphasizes strict compliance with licensing agreements for music streaming companies to prevent copyright infringement claims. The copyright may lead to changes in streaming music services business models, requiring platforms to rethink their music acquisition and licensing policies. The Copyrights Act of 1957 and the Trademarks Act of 1999 are two significant laws that govern the protection of IPR. Section 62 of Copyright Act 1952 provides for the jurisdiction of a district court at a place where the plaintiff actually and voluntarily resides, carries on business works for personal gain at the time of instituting the suit proceeding. Section 134 of the Trademark Act 1999, in conformity with the CPC, provides for the plaintiff to file a suit for infringement and a suit for passing off in the district court at the place where the defendant carried on their business. Supreme Court's interpretation of carrying on business. The SC in Doda House versus SK Mengai ruled that carrying on business and personal works for gain are distinct terms. Carrying on business involves having an interest in a business, a voice in what is done, and a share in the gain or loss. Conditions for an entity to be considered carry on business under the Copyright Act and Trademarks Act are: the agent acting through the entity must be a special agent who exclusively attends to the business of the entity and acts in its same name. The essential part of the business must take place within the jurisdiction in question. Now let's understand this concept by a few more cases. World Wrestling Entertainment versus Miss Reshma Collection and others. The court interpreted whether the grounds complied with the three conditions set out in Doda House to constitute carrying on business under these acts. The court interpreted the third condition as the essential part of the business within the jurisdiction in question. The court came to a conclusion that contracts made via the internet concluded at the place where the acceptance of the offer is communicated to the offerer. The second case is Millennium and Copthorne International Limited versus Arians Plaza Services Private Limited. Court ruled no distinction between an entity with its interactive website and one using a third-party website for carrying on business. Reservation made by a consumer on a third-party website is considered carrying on business even if payment isn't made. Example: a hotel in Mumbai, Delhi and Chennai can be considered carrying on business if reservations are made through a website. Cause of action. A cause of action is the bundle of facts combined with applicable laws to give the plaintiff the relief sought. In determining the jurisdiction of a court, The cause of action arises when infringement of a copyright or trademark happens on the internet. The Banyan Tree Holding Private Limited versus Murali Krishna Reddy, the court analyzed the position of law in determining the cause of action and jurisdiction of a court when the passing of and or infringement happens on a website and neither party is within the territorial jurisdiction of the court. The court observed that more interactivity of the defendant's website in the forum state would not give jurisdiction to the court. The plaintiff would have to prove that the defendants purposefully availed the jurisdiction of the forum court, targeted consumers in the forum state of for commercial transaction, had a detrimental effect on the plaintiff's reputation, and that these commercial transactions are real life commercial transactions. So, lastly, we conclude that copyright infringement and territorial jurisdiction are crucial legal concepts in protecting intellectual property rights. Copyright laws are territorial rights. However, as digital content can be easily disseminated across borders, the internet has challenged traditional territorial jurisdiction. International treaties and agreements, along with some countries' extraterritorial provisions, provide a framework for addressing cross border copyright issues. The global connectivity and rapid advancement of technology necessitates the need for consistent international copyright laws and efficient enforcement mechanisms to safeguard intellectual property rights, requiring legal frameworks to adapt to the digital environment and safeguard the rights of creators and copyright owners. Thank you.